The research shows, and also our experience in the Sandridge program shows, that having some sort of transitional period promotes community safety and also helps the individual also acclimate to society once again. Unbeknownst to most people in Wisconsin, the Sandridge program is considered the bellwether among facilities of this type. It's the best program recognized nationally and internationally for its advances in treatment, assessment, legislation as well.
And that relates to both the inpatient and outpatient portions of the program?
That's correct.
And
well, Mr. McGee is one of several Racine County residents for whom we've been searching for an appropriate residence for a number of months. And initially, one of the obstacles to that were the local ordinances. We did examine the online databases that Ms. Serwa testified about. So we look at Zillow and Realtor.com and Homes.com and a number of other places. We also post ads on Craigslist. We contact our vendors to see if they have any properties or if they know of any properties that they believe might meet the statutory criteria, or in prior to 156 it would be if they fell within outside of the local ordinances. So we do a number of different things to try and identify properties.
now, identifying a property in Racine County is not a new problem.
It has been one of the more difficult counties for us to find placements.
Okay. It's the desire of the department to keep people, if possible, close to home.
Absolutely. The Department of Health Services excuse me, does not propose any placement outside the residence, outside the patient's county of residence unless we are directed to do so by a court.
And that happened in this case?
Yes.
If that had not happened, would there be any placement for McGee anywhere?
No. Well, when we have there's something specific to this particular case that I need to incorporate here, and that's that we had an initial order to place in either Kenosha or Racine. And so we contacted both of those Department of Health and Human Services departments, asking them for, alerting them of the order, and asking them for any assistance they could provide in terms of identifying potential residents. We also, when we do, in fact, identify a residence, Act 156 requires us to contact local law enforcement, and we did that in this case with regard to the letter that was sent to the sheriff requesting a residence, RISIDENCE evaluation. And this is done to ensure that we are aware of any potential circumstances regarding neighbors that might affect the viability of the placement.
And you did all those things?
Yes. We also have a core meeting that is convened after a certain period of, after the plan has been approved by the court. And this involves the people who are involved in the placement. So Department of Corrections is represented, the Sheriff's Department is represented, local law enforcement may be represented, and there's a DHS representative attending as well.
Okay. So all those people have notice before the placement?
That's correct.
Do those people get input on the placement or just notice?
They get notice of the placement. If they can't provide any compelling evidence that would suggest the placement is inappropriate, we welcome that information. And that happened actually in the case of the individual we intended to place with Mr. Michael McGee, that we subsequently learned that there is some rather obscure case law that was pertinent to this situation. And it resulted in us widening our interpretation of serious child sex offender as it's defined in Chapter 980, so that we now understood that there were predecessor crimes that should have been considered. It wasn't made clear in Chapter 980 or in Act 156, so it was helpful to us to have this information about this obscure case law that led us to believe that this was not an appropriate placement for the other individual.
Okay. And so what did you do?
We rescinded the placement, and we have returned back to Milwaukee County Court for further disposition of that case.
Okay. That's in Milwaukee then?
Yes.
What is your opinion today as it relates to this placement?
This is a viable, lawful placement for Mr. McGee.
Does it meet the requirements of the act that you have to incorporate within your plan?
Yes.
And though maybe not a perfect placement, it's the only one you have?
That's correct.
Now, when there's maybe an imperfect placement, or one that meets minimum criteria, can you use them as temporary placements?
We can, and in fact, in several of our other out-of-county placements, the court has directed us to continue searching and for us to construe these placements as temporary.
Okay. And that's actually what's happened with Kenosha County's 90-day releases previously.
That's correct. We did have someone placed there in 2012, I believe.
But with regards to Mr. McGee, before Act 156, he had this Kenosha County residence picked up, correct?
Before Act 156?
Before Act 156.
We actually did look at this property once again in July of 2015, not only for Mr. McGee, but for our other residents who either had an out-of-state, or excuse me, an out-of-county placement order or were Kenosha County residents. We did look at its viability at that time and determined that the local ordinances precluded placement.
With regards to Mr. McGee, when did you select the town of Cleveland residence as possible placement?
I believe I sent an email to the supervised release team, the folks I supervise in the supervised release program, on March 3rd, 2016. So shortly after Act 156, in fact, the day after Act 156 was published. Well, unfortunately, we've had a loss of staff. The staff member who was primarily responsible for conducting those kinds of activities and also maintaining our resident search log resigned in February. And so since February, the log is not as well kept as it was previously.
And that happened before the law changed, correct?
That's correct, yes. Well, our clients are subject to different rules than DOC. DOC supervisees have to follow local ordinances. DOC also has transitional living facilities or placements where they can place a number of individuals in a restricted area. We don't have the luxury of some of the advantages that DOC has in terms of our supervision of Chapter 980 patients.
DOC has to follow local ordinances and you do not, correct?
Correct. They did have knowledge of the specific placement.
Is it your testimony that the sheriff's department knew that Mr. McGee was going to be placed here before the decision was made?
No, it's my testimony that the sheriff's department was informed of the placement location that we intended to place an individual.
How can the sheriff's department share concerns if they don't know who's going to be placed there?
The information we're asking from law enforcement is to provide information about people who reside in adjoining properties so that we can comply with the statutory requirements. We do not ask for individual recommendations regarding particular patients. Generally, law enforcement officials lack the requisite training and experience to provide informed information about residents, R-I-S-I-D-E-N-T-S. That's why we ask for their input about placements, not particular people.
You would agree with me that law enforcement in the county of attended placement knows its community, correct?
That's correct.
And you would agree with me that they know who resides where and who lives in certain houses
That's why we ask for their input in that regard.
with regards to placements. You said welcome input. So your testimony that you don't have to tell them who's going to be there or the background of their offenses at any time before the decision is made?
But they will know. They may not know at the time that we submit the plan, but they do know. There's a core meeting. There is also other opportunities for law enforcement to be involved in this process. I reviewed the most recent Chapter 980-07 evaluation report. I also reviewed his treatment progress report, most recent one from 2015, and some other records. But generally, I reviewed most of the things pertaining to placement.
Did you review anything relating to his past offenses, like the underlying convictions or criminal?
Well, my understanding is that he had one conviction for sexual assault of an adult female that apparently occurred within the context of an initial robbery that turned into a sexual assault. And I'm also aware of some charges that were brought against him in 1992.
And those charges consisted of what?
There was an allegation that he sexually assaulted his 10-year-old nephew, and also an allegation that he inappropriately touched an adult female at a party.